Welcome to WeLearn Virtual Learning Network. This is session number 9 of Indian Partnership Act 1932. Topics to be covered are characteristics, law of partnership, partnership assumes to fold character, formation of partnership, partnership deed, who may not be partners, test of partnership, cases where no partnership relation exists, partnership in other association, partnership in co-ownership, duration of partnership, registration of firm, effect of non-registration, partnership in co-workers, and the last one is rights and duties of partners. Now first I would like to tell you about partnership. A partnership is an association of persons who have agreed to share the profit of the business. The person who have entered into partnership with one another are called individually as partners and collectively a firm, and the name under which their business is carried on is called the firm name. According to section 4 of the Indian Partnership Act has defined partnership as partnership is the relation between two or more persons who have agreed to share the profits of the business carried on by all or any of them acting for all. Now characteristics of the partnership. First one is association with two or more persons. There should be at least two or more persons to form a partnership. If the number of partners get reduced to one by any reason, say death or insolvency of partner, it would cease to be a partnership. Second is agreement. A partnership originates from an agreement between persons. This agreement may be expressed or implied. It should also be noted that the partnership does not arise out of status as in the case of joint Hindu family. Next, business. Partnership can be formed only for the purpose of carrying on some business. Sharing of profits. Sharing the profits of business is the essence of partnership unless otherwise agreed. Sharing profit of a business implies sharing of its losses as well. Mutual agency is the last characteristics of partnership. According to this, the partners have relationship of mutual agency between them, and the law of partnership is regarded as an extension of general law of agency. Law of partnership, extension of law of agency. The partnership business may be carried on by all or any one of them acting for all. Thus, the relationship of principal and agent is established amongst partners, and this relationship is governed by the law of agency. A partnership assumes two-fold character. First one is he is an agent of the firm. So far he is dealing with the outside world for the purpose of the business of the firm are concerned. Second is he acts as a principal amongst other partners. Formation of partnership based on agreement. Second, partnership agreement can be made orally or in written. Essential elements of valid contract has to be present. Object of the partnership should be legal. Minor may be admitted to the benefits of partnership with the consent of all the partners. And no consideration required for forming agency, likewise for partnership also. Next is partnership. The document contain the agreement between the partners are called partnership deed. It means the document in which the terms of partnership as agreed by the partners are set forth is called a partnership deed. Contents of partnership deed: nature of business, place of business, name and address of partner, profit sharing ratio, interest on capital. Only complete who may not be partners. First, alien enemy. Second is minor. Third, person of unsound mind, and fourth is corporation. Test of. According to Partnership Act, the liability of partners is joint and several. It means that the creditors of the firm can realize their dues from any partner of the firm. It is quite possible that a person, in order to escape his liability, may deny the fact of his being a partner in the firm. In such situation, it becomes necessary for the creditors to prove that the person concerned is a partner in the firm. to determine whether or not a group of persons constitute partnership and whether a particular person is or is not a partner in the firm. We have ascertained the real relationship among the parties. If the parties have drawn an express contract, their real relation may be known from the term of partnership contract. But if they have not drawn any express contract, their real relationship is to be gathered from other relevant factors such as conduct of parties, circumstances under which the contract book took place, book of accounts, statement of employees, etc. According to section 6 of the Act, clearly state that in determining whether a group of persons is or is not a firm, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. Test of partnership includes agreement between the parties, real relationship between the parties, sharing of profit, and last one is mutual agency. Cases where no partnership relation exists. There are some cases in which no partnership relation exists. First one is joint owner, second sharing of profit, last one is member of joint Hindu family. Partnership and association. Partnership and joint Hindu family. Partnership and joint Hindu family. First one is mode of creation, interest of business, admission of new members, that is female, minor, fluctuating, authority of members, liability of members, right of members to demand account, and last one is registration. Partnership and co-ownership. Mode of creation, business, nature of interest, transfer of interest, number of members, authority of members, partition of property, and last one is lien for expenses. Duration of partnership. First one is partnership for a fixed term, second partnership at will, and third is particular partnership. First, partnership for a fixed term, it is for a fixed time. Second one is partnership at will, when there is no provision in partnership agreement for duration of the partnership, the partnership is called partnership at will. This is according to section 7. Last one is particular partnership, where a partnership is formed for a specific venture or for a particular period. It is called particular partnership. This is according to the section 8. Registration of the firm. Procedure for registration. First, to be the registered with registrar of firm. Content of application of registration. Effects of non-registration. Suits between partner and the firm. Suits between firm and third parties. Claim of set off, alterations, penalty for false particulars, inspection for registrar of firms and documents, and grant of copies. Rules of evidence. Relation of partners to one another. Rights of the partners. First one is right to take part in business, right to consult it, right to access account, right to share profit, right to interest on capital, right to interest on advances, right to prevent entry of new partners, no liability before joining, right to be an agent, right to retire. Last one is right to outgoing partners to share in the subsequent profits if his share is not settled by other partners. Duties of a partner. First one is to carry on business to the greatest common knowledge, to observe faith, to indemnify for fraud, willful neglect, to attend diligently, not to claim remuneration, to share losses, to hold and use the property for the firm exclusively for the firm, to account for personal profits, to account for profit in competing business, to act within authority, not to assign his rights, and last one is to be liable jointly and severally. Property of the firm. First is all property originally brought into the common stock, interest received out for the investment, all properties acquired during the course of business, goodwill, that is reputation, industrial contract, brand image, etc., which the firm has developed over the years. Agreement in restraint of trade. There are some exceptions in agreement in restraint of trades. First one is the partner shall not carry on another business while he is a partner. अगर वो partner है तो वो किसी और business को नहीं run कर सकता. Second is an ongoing partner may agree with his partners not to carry on a similar business within a specific period. जो outgoing partner होता है या जो partnership छोड़ के जा रहा होता है उससे ये एग्रीमेंट किया जाता है, उससे एग्री करवाया जाता है कि वो सिमिलर टाइप का बिजनेस नहीं स्टार्ट करेगा फॉर अ स्पेसिफिक पीरियड के लिए. Upon dissolution, some or all of them will not carry on similar business. Fourth one is after dissolution and sale of goodwill, partners not to trade with the same brand name. Relations of partner to the third party. Implied authority of a partner. Purchase goods on behalf of the firm. Selling the goods for the firm. Receiving payments. Settling accounts. Borrowing money, credit facility on behalf of the firm. Pledging on behalf of the firm. Engaging servants, employees for carrying the activities of the firm. Partners authority in case of emergency. Partners has authority in case of emergency if they are done to protect the interest of the firm and to prevent loss. Second, partner should act to situations assuming if it was not for his own case. Reconstitution of firm. Introduction of a partner, retirement of a partner, exclusion of a partner, insolvency of a partner, transfer of a partner's shares, and last one is death of a partner. Types of partner. First one is active partner. A person entering into partnership by contract and taking active part in the conduct of a business is called active partner. Second is sleeping or dormant partner. A sleeping partner is one who contributes to the capital of the firm and has a share in profits of the firm. Nominal partner, a partner who neither contributes to the capital of the firm nor takes a share in the profit or take part in the management of the firm is called nominal partner. Partner in profit only. If it has been agreed among partners that a particular partner shall have a share in the profits only and not be liable for losses, such a partner is known as a partners in profit. Sub-partner. When a partner agrees to share his profit derived from the firm with a third person, that third person is known as a sub-partner. Partner by estoppel or holding out. Normally, a person becomes a partner only by agreement, but for outside world, a person can only be treated as a partner by virtue of his contract. This happens by way of estoppel or holding out. According to section 28 first, when a person by word spoken or written or by his conduct represent himself or knowingly permits himself to be represented to a partner in a firm, he is liable as a partner in that firm to anyone who has on the faith of any such representation gives credit to the firm. Last one is minor as a partner. Dissolution of firm, it means it completely breakdown or extinction of the relationship between all the partners of the firm. It means a change in the relation of the partners. Such a change is usually caused when a firm is reconstituted, that is when a new partner is admitted or when an existing partner retires, die and become insolvent or is expelled. Dissolution of the firm without the order of the court or with the order of the court. Without the order of the court includes by an agreement, by compulsory dissolution or on the happening of certain contingencies, or last one is by notice. By agreement with the consent of all the parties in accordance with the contract between them, compulsory dissolution. First one is when one or all partners become insolvent, and second is by the happening of any event which makes it unlawful for the business firm to continue. Dissolution on the happening of certain contingencies, expiry of the term, completion of a particular adventure, death of a partner, last one is insolvency of partner or partners. Dissolution by notice, firm may be dissolved by any partner who gives notice that the partnership will no longer exist. In such case, dissolution is counted from the day when the notice is issued by the partner. Dissolution by court, insolvent, incapacity, misconduct, persistent breach, business working at loss, gambling of a partner in stock exchange, fraudulent breach, persistent refusal or neglect by a partner to attend the business. Right of partners on dissolution: have the right to wound up, right to have the debts of the firm settled out of the property of the firm, share the profit of the firm earned after dissolution, have the premium return or premature dissolution, restrain the use of the firm name or property by any partner for his own benefit. Liabilities of a partners on dissolution. First, if the public notice is not given, partner continue to be liable for any act done by any partner after dissolution. Second, to wind up the affairs of the firm in smooth manner. Third, to complete the transaction begun but unfinished at the time of dissolution. Settlement of account. Sale of goodwill, sharing of deficiencies. This is first out of profit, then out of capital, and last out of partners' individual proportion in which they are eligible to share profits. Application of assets, first to pay the debts outside and then to share among the partners in their profit sharing ratio. Public notice to be given when retirement, dissolution of a registered firm, addition of new partners. By how? By notice to the registrar of firm, by publication in the official gazette, by publication in newspaper. Consequences in public notice not given. First, on retirement, on dissolution, and on expulsion. Now there are some questions on the basis of this session. First one is, what are the characteristics of partnership? Partnership के क्या characteristics होते हैं? And last one is, what are different types of partners? Different types of partners को explain कीजिए और कौन कौन से होते हैं. Thank you. Happy learning, relearning.